and welcome back to another episode of Courts This Week presented by LiveLaw. I'm your host, Ostika Das, and I'll take you through the most significant courtroom developments from this week. From the Supreme Court to local courts, I've got you covered with crisp and clear summaries. But for a deeper understanding, I will always encourage you to check out the news articles available on our website, www.livelaw.in. In today's episode, we are going to talk about the latest developments relating to the Manipur ethnic clashes, the controversy over Congress leader Sachin Chaudhary's Modi-Adani love affair remark, the most recent Supreme Court Constitution Bench judgment, and much more. So let's dive into the headlines. In a significant decision, a Supreme Court Constitution Bench headed by Justice Sanjay Kishan Kaul declared that the 2014 judgment in Subramanian Swamy, which invalidated Section 6A of the Delhi Special Police Establishment Act 1946, would have retrospective effect. In this judgment, the Supreme Court struck down Section 6A, which mandated government approval for the CBI to investigate certain high-ranking officials for corruption. Now the court has ruled that this section will be considered to not have been in force right from its inception. So what does this mean in simpler terms? Article 13 Clause 1 says that pre-constitution laws or laws that were enacted before our constitution came into force would be void to the extent of their inconsistency with the constitution, while the second clause of the article prohibits the state from enacting a law contrary to the provisions of Part 3 of the constitution containing fundamental rights, declaring that any such law would be void. Although void has been used in both clauses, there is a key distinction, and the Supreme Court has reiterated that in this judgment. While under the first clause, a pre-constitution law is considered to have subsisted for some time till the constitution itself was enacted and some provision was made which the law ran contrary to, any law made after the enactment of the constitution that is found to be in contravention with the provisions of Part 3 would be void right from its birth. So once such a law is held to be unconstitutional, it would be considered void ab initio, stillborn, unenforceable and non-est. The bench therefore held that the struck down Section 6A of the Delhi Special Police Establishment Act would be considered to not be in force right from the date of the enactment of the provision. The court also reiterated that any change in procedure after an offence is committed would not be unconstitutional on grounds of Article 20, Clause 1, which bars an individual from being convicted or sentenced under an ex post facto law, which means the law that was not in force at the time when the crime was committed. This article, however, does not affect procedural matters, and accordingly, the Supreme Court bench said that Article 21 would have no bearing on either the validity or invalidity of Section 6A of the DSPE, since the provision was purely procedural in nature. There are two important developments about Manipur which has been witnessing ethnic clashes since May. The first development is with respect to the FIRs filed against members of the Editors Guild of India over alleged misrepresentations in their fact-finding report related to the ethnic violence in the northeastern state. Among other things, the report claimed that the Meity-dominated press in Imphal had fanned the violence by publishing misinformation that favoured the majority Meity community. This week, a bench led by Chief Justice D.Y. Chandrachud extended the protection it had earlier granted to the Editors Guild members against coercive action. The complainant argued in court that this report was one-sided and had aggravated the situation on ground. Chief Justice Chandrachud, however, criticized the complaint as essentially a counter-narrative of the government. Besides this, the bench also questioned whether an offence of promoting communal enmity between different groups could be made out on the basis of the report, even assuming it to be false. During the hearing, the court, while expressing its disinclination to quash the FIRs and the criminal proceedings arising out of it, mulled over the idea of transferring the case out of the Manipur High Court to the Delhi High Court. Moving on to the second development relating to the Manipur ethnic clashes. Earlier this month, reports emerged that the home of Professor Kham Khan Suan Housing's lawyer had been vandalized by a mob. For context, Housing is a kooky professor and a vocal critic of what he says are the ruling Bharatiya Janata Party's integrationist and majoritarian agenda that allegedly set the stage for, and I quote, state-sponsored violence against Kuki Zomi tribes in the northeastern state. Professor Housing has also spoken out against the alleged role of the Métis outfits in the ongoing ethnic clashes. Some of his statements have led to a police complaint being registered against him, accusing him of defaming the Métis community and provoking communal enmity in the state. Notably, the Supreme Court granted the political scientist protection against coercive action while he approached the Manipur High Court. However, the Hyderabad University professor was left with no legal representation after the recent attack on his lawyer's home and office, which was followed by his lawyers withdrawing from the case. This week, senior advocate Anand Grover specifically flagged this issue of individuals from a certain community facing legal issues owing to the reluctance of local lawyers to represent them in the face of threats and intimidation. Grover was representing two petitioners. The first petitioner, a 76-year-old retired Indian Army colonel, is facing an FIR for his book about the 1917 Anglo-Kuki War, published in January 2022. The second petitioner is an activist against whom an FIR was lodged over a speech he delivered. The Supreme Court has backed the ban on the manufacturing, sale, storage and use of firecrackers announced by the Delhi government for the third consecutive year as a part of its action plan to curb pollution in winter. While declining to interfere with the firecracker ban, a bench headed by Justice A.S. Bopanna stated that if a local ban existed, the court would not interfere and suggested celebrating in alternate ways. In a lighter vein, the judge suggested going to a state where firecrackers are allowed. The bench was hearing BJP MP Manoj Tiwari's plea against a complete ban on firecrackers filed last year ahead of Diwali. Tiwari's counsel argued that despite Supreme Court directives against a complete ban, several states including Delhi have implemented one. The court, however, has consistently expressed reluctance to overturn the firecracker ban due to Delhi's high air pollution levels. Last year, a bench headed by Justice M.R. Shah, who is since retired, advised spending money on sweets to celebrate Diwali rather than bursting crackers and causing air pollution. While hearing a connected matter, the court questioned Delhi police over how it planned on implementing this firecracker ban, emphasizing that issues relating to violations must be proactively nipped in the bud by identifying the sources instead of taking punitive action against people bursting crackers after the violation has taken place. During this week's hearing on the remission granted to Bilkis Banu's rapists, the Supreme Court questioned if the non-payment of fines by the convicts would be an important consideration when examining their conduct in jail. Notably, senior advocate Siddharth Luthra argued that no legal consequences would flow from the non-payment of the fines, since any consequent default sentence would be subsumed within the life terms handed down to the convicts. At the same time, on the last occasion, he informed the court that the convicts had recently submitted the outstanding amounts to the convicting court in Mumbai. One of the arguments made by the Gujarat government as well as the private respondents is that the remission was legal because the convicts were prematurely released only after taking into consideration the host of relevant factors in terms of the applicable remission policy. One crucial factor in this determination was their conduct in jail, which has, according to the counsel for the respondents, been excellent and deserving of premature release. This has, of course, been disputed by the petitioners, who have, among other things, pointed out that none of the convicts had bothered to pay the fines that were imposed on them, the fines that the Bombay High Court categorically said would go towards compensating the gang rape survivor. The argument made by the petitioner's counsel was that this willful and deliberate non-payment of fine, which the convicts knew was supposed to be paid to Bilkis Banu, demonstrated their lack of remorse. Interestingly, Justice Ujjal Bhuiya asked a question along the same lines this week. He asked senior advocate Siddharth Luthra, will the non-payment not come within the meaning of the convict's conduct? Will this not be a relevant consideration? The debate over the premature release of the 11 convicts will continue on 20th September, so stay tuned. Also, don't forget to visit our website www.livelaw.in to read our detailed reports on each day of the hearing. While hearing a significant case dealing with police procedures during A. encounters and B. media briefings amid ongoing criminal investigations, the Supreme Court has ordered the Union Ministry of Home Affairs to create a comprehensive manual for police media briefings within 3 months. The bench led by Chief Justice Chandrachud also instructed all State Director Generals of Police to provide their suggestions for this manual. Furthermore, the court emphasized the importance of considering input from the National Human Rights Commission in developing these protocols. In an important development, the Supreme Court has referred a batch of petitions challenging the constitutionality of Section 124A of the Indian Penal Code containing the offence of sedition to a bench of at least 5 judges. Now, there are two important aspects to be noted. First, the bench headed by Chief Justice Chandrachud turned down the request made by the central government to defer the hearing in view of the introduction of Bharatiya Nyaya Sanhita, which seeks to replace the existing colonial-era penal code. The court said that even if this new bill becomes law, the pending cases under Section 124A IPC will not be affected as BNS would only apply prospectively. Second, while making the reference, the court noted that the 1962 Kedarnath Singh judgment, which upheld Section 124A, did not consider the aspect of Article 14 of the Constitution. It must also be remembered that in May last year, the Apex Court had ordered sedition law to be kept in abeyance till the government reconsidered the provision, which many have criticized as draconian. In a significant move towards judicial reform and transparency, Chief Justice Chandrachud has announced that the Supreme Court is now officially on board with the National Judicial Data Grid. Developed by the National Informatics Center in collaboration with the Supreme Court's in-house IT team, the NJDG is a repository of real-time data on cases in district courts and high courts across India. This data is categorized by case type, year, stage, and forum. The Chief Justice announced in court this week that for the first time, Supreme Court data would also be available on this portal and conducted a small demonstration of the features of the website and the information displayed on it. Later in the same day, Prime Minister Narendra Modi commended the Supreme Court and the Chief Justice of India for this technological advancement, emphasizing technology's role in promoting transparency. The Supreme Court has declined to intervene in the Lakshadweep administration's decision to exclude chicken, beef and other meats from school children's midday meals and the closure of dairy farms in the archipelago run by the Animal Husbandry Department. In 2021, these measures were introduced by the Union Territory Administration, sparking legal challenges. A local lawyer petitioned the Kerala High Court, which initially issued a stay but eventually dismissed the PIL. An appeal was made to the Supreme Court after this against the Kerala High Court's decision, and a bench headed by retired Justice Indira Banerjee had stayed the administration's orders again in May last year. The Apex Court, however, has vacated the stay now and dismissed the petition. A bench of Justices Aniruddha Bose and Bella M. Trivedi refused to interfere, citing limited judicial review in matters of executive policy, especially when no legal breach could be made out. The court also acknowledged that the administration had retained non-vegetarian items like egg and fish, which ASG KM Nataraj insisted was readily available on the islands and met the nutritional requirements of the school-going children. After dictating the order, Justice Bose notably made a passing observation that personal preferences could not be imported in policy matters. The Supreme Court has rejected a petition by Sachin Chaudhary, the Secretary of UP Youth Congress, to quash an FIR filed against him. This FIR was related to his alleged comment about Prime Minister Narendra Modi being in a love affair with industrialist Gautam Adani. Chaudhary's plea was against an Allahabad High Court order refusing to quash the FIR. The High Court determined that the alleged offence fell within the purview of Sections 153A and 505 of the Indian Penal Code. While rejecting the plea, a bench of Justices Aniruddha Bose and Bella Trivedi stated that the investigation by law enforcement was ongoing and any intervention by the Apex Court at this stage would be premature. In an important development, Chief Justice Chandrachud, who is known for his vocal support of hybrid court hearings and e-court initiatives, presided over a case where the petitioner raised concerns about the complete cessation of virtual hearings by the Punjab and Haryana High Court. During the COVID-19 pandemic, virtual hearings were allowed, but they have now been discontinued. Taking note of this, the Supreme Court sought the response of not only the Registrar General of the Punjab and Haryana High Court, but also all other high courts in the country. The court has directed them to provide affidavits stating whether they continue to allow virtual hearings and, if not, to provide categorical reasons for the discontinuation. Additionally, the bench has requested similar information from registries of National Company Law Appellate Tribunal, the National Consumer Disputes Redressal Commission and the National Green Tribunal, and requested Solicitor General Tushar Mehta's assistance regarding various tribunals under different ministries. Besides emphasizing its continuing commitment to hybrid hearings, the Supreme Court also expressed its concerns over the discontinuation of virtual hearings by several high courts, despite substantial investments in e-court infrastructure. Next, let's turn to news from high courts and other courts of the country. The Kerala High Court has quashed criminal proceedings against an individual who had been arrested by the police for watching pornography on his mobile phone in a public place. Justice P.V. Kunhikrishnan emphasized that privately viewing explicit content on one's phone without distributing or publicly displaying it does not constitute an obscenity offense under the Indian Penal Code. The court reasoned that an individual's choice to view such content in private is a matter of personal privacy and the law should not intrude into it. The judgment also clarified that Section 292 of the Indian Penal Code, which deals with obscenity, applies only when someone attempts to circulate, distribute, or publicly exhibit obscene material. At the same time, Justice Kunhikrishnan cautioned parents about the accessibility of explicit content on mobile phones and encouraged them to supervise their children's device usage. Not only this, the judge also implored parents to send their children for outdoor activities and welcome them back home with the mesmerizing smell of mother's food. The Delhi High Court has directed the Delhi government to furnish a comprehensive status report on the rehabilitation of children rescued from child begging activities and placed in rehabilitation centers within the city. Acknowledging the persistent issue of child begging, the court asked the government to assess the rehabilitation center's long-term impact on these children and include this assessment in their report. The government has been granted a 6-week time frame to submit the comprehensive report. This directive came in response to a public interest litigation that seeks effective measures to combat child begging in the national capital. The plea also highlighted the involvement of organized begging networks exploiting innocent children and called for their identification and rehabilitation. Last month, the Gujarat High Court refused to grant any interim relief to Delhi Chief Minister Arvind Kejriwal and Aam Aadmi Party's Rajya Sabha MP Sanjay Singh in their plea seeking a stay on criminal defamation complaint proceedings. For those who are unaware, these proceedings have been initiated after the Gujarat University filed a complaint accusing Kejriwal and Singh of making sarcastic and defamatory statements targeting the university regarding Prime Minister Narendra Modi's degree. The Ahmedabad magistrate trying the case has summoned Kejriwal and Singh to be physically present in court. Notably, Kejriwal was also denied relief by the Supreme Court, which refused to stay the trial in the criminal defamation case in view of the litigation pending before the High Court. This week, in another setback, a sessions court in Gujarat dismissed a revision application filed by Kejriwal and Singh, challenging the magistrate's order summoning the duo to be physically present in court. That wraps up this week's legal news roundup. But before I go, I have a little request from the entire LiveLaw team. We are an independent, fact-driven media organization that is committed to fearless and ethical journalism. To keep delivering your daily and weekly legal updates, especially in this dynamic audio-visual format, we need your support. So don't forget to do the Fantastic 6. Give our video a thumbs up, share it with your family, friends, classmates and colleagues. Make sure you subscribe to our YouTube channel. Drop your thoughts and feedback in the comments below. Tap that bell icon to get your notifications, and lastly, swing by our website at www.livelaw.in for our in-depth reports. I'm your host Ostika Das and I will see you again next time.